Okay. Well, thank you all for turning out. I do have a lot to cover here. I want to start with dual agency procedures. This comes up frequently about when we have a listing, and let's start with just simple dual agency, which is when we have a listing and an agent from our company brings in a purchaser. Even if it's a different office, say we have a listing in Sonoma and an agent from Santa Rosa brings in or Parmita from Petaluma brings in the offer, that's dual agency because we both are working under the same brokerage umbrella. So that becomes dual agency and has to have the agreement of all parties to work with the dual agency. What is more complicated, and I always say it creates the biggest target on our backs for litigation, and that's single agency, dual agency. And that's when the listing agent also is representing the buyer for the property. And of course, that takes both parties to agree to it, and some skillful detachment, if you will, by the agent to not disclose material facts of one party to the other party. And material facts are kind of a legal state of art term. There's no pure definition of what is a material fact. It depends on the circumstances. What might be material to one party may not be material to another. So if you're in a single agency, dual agency situation, or a single agency situation, we do have procedures, and that is you call your broker manager, and they get involved in negotiating one side of the transaction. Typically, if I get called in that situation, I'll work with the seller in reviewing the offers, and we'll explain to the seller that okay, to have an arm's length evaluation of the offer, I will go over the offer with them and create a counter offer or negotiate terms, and then once the contract is finally negotiated, then the listing agent, the original listing and selling agent, steps back in and handles the transaction. And once in a while, when negotiation comes up in let's say during the request for repairs period or something like that, I'll step back in again and help the seller evaluate the request for repairs or something like that. Again, it's so we have an arm's length kind of situation with all the parties. So if you do get into a single agency, dual agency, please speak immediately to your nearest broker manager. And it also comes up where in multiple offer situations, we might have the listing agent is writing an offer for one buyer, and then we have, say, 2 or 3 offers coming from other brokerages and agents. And in that situation, the listing agent has to be sure not to look at those offers, because that would be an unfair advantage to them and their buyer, knowing what the other parties are offering. So in those cases, when you know you're going to be writing an offer on your own listing and you know there's going to be other offers coming in, you ask those other offers to be delivered in sealed envelopes or emailed to your broker manager, and not certainly don't put your hands on them and look at them, because that puts us in a very, very difficult situation. So I think that covers dual agency. Any questions on that? Okay. Connected to dual agency is something in the MLS, not in the contracts law so much, but in the MLS, there's something called dual and variable commission. There's a box in the section that's offering compensation to the selling agent. And next to that, there's a question. It's dual or variable commission, and it says yes or no. Anyone want to explain what that is? Calling for volunteers. Go ahead, Barmita. You know what that is. She's
sorry, I missed the question.
okay. I'm seeking to explain what dual and variable commission means in the MLS.
Oh, I don't know. I actually.
Okay, Kamala, is it?
Yeah, Kamala.
Kamala, hi Kamala.
Hi, everyone.
Yeah, Kamala's a new agent with us who, she's a broker, right?
I'm not a broker, but hopefully someday soon.
Great. So Kamala just joined our, I think you'll be working out of the Petaluma office, right?
That's right. I'm really excited.
Great. Nice to meet you virtually here.
Nice to meet you.
Okay, so could you give us an explanation of dual and variable commission.
Well, my understanding, and I might be incorrect, is that when there's a dual agency, then the seller can negotiate the commission rate if everything is in-house. So there's one rate if the buyer and seller are from the same broker, and then a different rate if the buyer and seller are from different brokers.
Correct. That's a good explanation. So what happens is sometimes the seller will say, well, you're taking the listing, let's say, and the seller asks you, well, what if you sell the property yourself? Will you reduce your commission? And I always coach our agents to say, well, I'll need to check with my manager. It's something called, in Roger Savvy's terms, he uses an acronym called PAID, P-A-I-D, and the P part is pause. So before you answer any commission request for a commission reduction, you always want to pause. And one of the answers is, well, the I is isolate. I think the A is assess, and I'll send out the paid. Rogers just sent me a nice summary of what the paid approach is in negotiating commission objections. But anyway, we usually do agree that we'll reduce a commission if we handle both sides of the transaction. And sometimes it's just for me personally as the listing agent. If I bring in the offer, I'll do it for 5% instead of 6%. And sometimes it's for our whole brokerage. If someone in our brokerage brings in the offer, I'll do it for 5 instead of 6%. And then that creates what we call a dual or variable commission. So we're obligated to check that box in the MLS. And if you're looking at a listing for your buyer, and this field is not one that goes out to the public or your buyer would see, but we see it as agents, and you see the dual or variable agent checked, your counsel is to call the listing agent when you're going to be writing an offer and say, I see there's a dual or variable commission. Can you explain that to me? What is the situation? And then they're obligated to explain to you, well, if someone from our firm, say it's a Coldwell Banker listing, so if someone from our Coldwell Banker brokerage brings in an offer, it's going to be a reduced commission. And then I said, then your next question is, well, do you know if anyone is bringing in one? Because you want to be on the same level competing field with the other parties. So if they say, yes, I'm bringing in an offer myself, you said, well, how are you handling that? Your broker going to handle it, or and what is you can ask, what is the dual or variable arrangement? And they said, well, we're doing it for 1% less on the seller's side if if we do a dual agency. So then you can take that into account in your offer and have a level playing field. So that's what the dual and variable commission field in the MLS is about. Any questions on that? Okay, keep an eye out for that, because I've had deals where our agent made an offer. They didn't know it was a dual or variable commission. Actually, the broker hadn't checked the box. But during the negotiations, that broker, one of their agents bought an offer, and they negotiated during the process a reduced commission, but they never told us about it. We took it to arbitration at the board because it sold for less than what our agent had bought an offer in for, but the commission was less, so that the seller still netted more. But they didn't tell us, so we said that was a violation. But we lost the arbitration, but that's another story. TDS, I want to go over the TDS a little bit because this came up. One of our agents who's on the call here. And what happened was there were multiple offers on a property. We had the listing. The buyer, the seller, our client, chose one of the offers because it was a cash offer, and they had waived all contingencies in their offer. They had submitted a CR form that waived all contingencies and conditions, and which the seller liked, because then they aren't subject to RR down the road. That happened on a Thursday. On Monday, the buyer's agent called with her hat in her hand and said, "I'm really sorry and I'm really upset, but our buyers decided they want to cancel the transaction." And we kind of said, "Well, that's not good." So we said, "Well, on what grounds do they want to cancel the transaction?" He says, "Well, they really don't have any grounds, but they hadn't put their deposit in, and they just want to cancel." And we said, "Well," so our agent called me, and I called our attorney and said, "Okay, on what grounds can they cancel?" And they said, "Well, they really can't cancel except if the TDS, the transfer disclosure statement, had not been delivered to them yet until the escrow opened. Then they had, and it was delivered electronically, they have 5 days after the electronic delivery to cancel the transaction for any reason under the TDS statutes." So we tried to go back and see when the TDS was actually delivered to this party. And we had a written confirmation that it was like on Thursday, the day was a day after the contract was ratified. So the statute goes like this: if the buyer has the TDS prior to the offer being presented, the buyer has the TDS in their hands and has read it prior to the presenting an offer, then they've waived their right to rescind the contract. They don't have a 3-day right, they don't have a 5-day right. Now, if they receive the TDS after their offer has been presented, then they have 3-day right if it's hand delivered, and a 5-day right of rescission if it's electronic delivery. So in this case, we were unsure whether they had it before or not. We think they had it before, but they only signed off on it the day after the offer was presented. So the seller, just to get closure on what happened with the transaction, the seller wanted to go after, their liquidated damages, even though there wasn't a deposit made. And legally, they could have done that, but they'd have to file a suit and hire an attorney and go file a suit and chase the $24,000 on an $800,000 sale, and probably protect that out for 2, 3, 4 months before they got a settlement of a legal settlement. So we said, well, we'll tell them that, you know. So I talked to the broker for the buyer's agent and said, hey, the seller wants a check. See if the buyer will write us a check to get out of the transaction. And of course, the buyer didn't want to do that. In the meantime, we had a backup offer, and the backup offer went to the first offer. So the seller said, forget about it. So he signed off on the cancellation, and we proceeded with the second offer with no harm, no foul. But if you're representing a buyer and they do decide to cancel, and then they may need to speak to qualified California legal counsel to make sure that they have the right to do that and they won't lose the deposit. Armida, did you have your hand up?
No, I was just wondering if that's the same case for Avids too, because I sometimes
No,
it's not.
Avids can be delivered and it doesn't trigger a re-review of the TDS.
Okay, thank you.
TDS statute just deals with the TDS itself, not the agent's part of it, the Avids. Okay. Any other questions on that? I see Laura and Roberto are on. There's
Mary, I wanted to just make a comment.
Yes, go ahead, Maria.
I was in the exact same situation on my last transaction as well. So I'm
Yes.
wondering if that's happening more often. Buyers are coming in and making all cash offers, removing all contingencies, and then a couple days later, they're wanting to pull out.
Well, if it happened to you and it happened to another one of our agents, I'd say it's happening more often, yes. And it may be this what I would say heated market, that buyers get in and all of a sudden they have buyer's remorse, you know, and get cold feet. And actually, it's an interesting scenario. Our agent in the case I was discussing said, well, what, you know, if the other party asked why did your escrow cancel? And, you know, we can just say, well, the buyer got cold feet. You know, we don't necessarily have to go into detail unless it is something that was not disclosed before that requires a new disclosure. But if it was something that was already disclosed and so forth, we don't have to go into the details of why that buyer canceled necessarily. But you know, it may be happening more. I don't know, Laura, do you see more cancellations of escrows? Are you seeing that?
No,
No?
not really, not at all.
All right, great. All right, you have your hand up. Go ahead.
Yeah, I was also under the impression that anytime any new information is brought by the sellers to the buyer, they have another 3 or 5 days to change.
Yeah, if there's something that's material, again, material is a state of art term, but if there's a material fact that becomes disclosed during the inspection period or after the original TDS was delivered, and it would trigger an amendment of the TDS, amended TDS does trigger just as a new TDS would.
I recently had a transaction where my clients, I was representing the buyers, they waived their contingencies, but they still wanted to do inspections. And the seller was pushing back on that and saying, no, you can't even do inspections. You waived your contingency. And both agents on both sides had conversations with CAR Legal and got different information at different times from different people. Ultimately, the sellers agreed to allow my clients to do their inspections, but they also provided an addendum after that with all this new information about the house.
Oh, okay.
So it's just kind of a interesting situation I wanted to share.
Yeah. I'll go into two forms after we're done with this particular topic. Yeah. Mari, go ahead.
Yeah, what about the SPQ? Is that the same as the TDS or is that?
No, the SPQ is not a statutory document.
Uh-huh.
The TDS is dictated by the statutes, and all the laws surrounding the TDS is statutory. The SBQ is just a form we use. So if there's a change in the SBQ that doesn't trigger a change in the TDS, that doesn't create any new thing.
Okay, great. Thank you.
Okay, let's look at the TDS form here real quick. Can you see my my screen? Somebody say yes verbally, please.
Yes.
Okay, thanks. Okay, thanks. So here's a real estate transfer disclosure statement. And one thing to protect your seller when you're taking the listing is to make sure they check this box. Inspection reports completed pursuant to the contract of sale or receipt of deposit. So this is number one, the very top of the TDS. So what happens here is if you have your seller check that box, advise them to check that box, that if the termite report turns up something that the seller didn't know about, you know, dry rot under the deck that the seller didn't disclose, and they normally would have had to disclose it as a defect. If they've checked this box, the inspection report, that pest report is part of their disclosure. So it doesn't trigger a new TDS. It's already here that it's part of their disclosure. So that's a protection for the seller. Also, the seller, you could check 2 here with additional inspection of reports or disclosures. Let's say the seller bought the house 2-3 years ago and they have all their old inspection reports from when they bought the property. We always advise them to give us copies. We'll attach them to the file and check this box and put them down what they are that they're going to be adding there. The last thing we would want our seller to do is check this box, no substituted disclosures for this transfer, because that kind of doesn't give them any additional stuff to fall back on. So pay attention to that area and review it with your seller when you're counseling them about the TDS. And then for the contingency removal, Annalise, this is a distinction that is good to make, that there's investigations and there's inspections. So you could remove under 2A here, buyer removes only the following individually checked buyer contingencies. And one, you could choose in buyer total investigation contingency under paragraph 12. Or then you could check paragraph C2 here, only the part of the investigation relating to inspections concerning physical attributes of the property. So if they want to do additional investigations just for, let's say they want to have their architect to go into the property or a general contractor, but they're happy with the inspections, or let's say they've removed their physical inspections. They've accepted, the seller had a home inspection and a pest report, and they're accepting those, and they're accepting the physical attributes of the property, but they want to do additional investigations, then you would check this box. Only the part of the investigation related to inspections concerning the physical attributes of the property. And then, you know, there's other choices, all buyers investigations other than the physical attributes, and so forth and so on. So that's a distinction that you want to be careful of when you're removing conditions, whether you're going to have additional investigations, even though they aren't physical property investigations. We've had those situations, and the seller the buyer wanted to go back in. You know, the seller's not obligated to let anyone back in the property from the buyer's side after they've removed the physical, after they've removed all their investigations. But if you check that number 2 and they still have investigation rights, then they can go. Now, after, let's say it's the default 17 days for removal of all investigations, and they want to go in after the 17 days, that's when we as agents have to negotiate with the other agent and the seller as a courtesy to let the buyer back in the property to take their architect through or the contractor and so forth. So, and 90% of the time, 95% of the time, the seller will get, agreed, and, but we've had circumstances where the seller just says, no, I'm not letting them back on the property. They have the legal right to do that. Okay, we're about 11:30. I'm Laura from First American, a reporter here. I'm going to put you guys on in about 10 minutes, and you'll have about 15 minutes for your show. Is that okay?
But it's Fidelity National Title, Gary.
What did I say?
First American.
First American.
Oh, I am sorry. My
That's okay.
faux pas.
Gary and I go way back. So
Yeah, Laura, you
I'll
know
talk
that.
another time.
Fidelity National Title. We'll say it a number of times between now and then. Okay.
Yeah, we're good. Whenever you need us, we're here.
Okay, thanks a bunch. Other issues that came up in the past week or so and come up pretty often is the buyers made an all-cash offer. They produced a proof of funds, and then they decide they want to get a loan in the transaction. Can they get a loan? Somebody said, give me an answer.
Can you repeat that?
Who was that?
I was just asking if you could repeat the question.
Oh, I'm sorry. The buyers made an all-cash offer. They provided proof of funds. The RPA, it says, no loan, but they want to get, after they get into escrow, they want to get a loan on the property. Are they allowed to do that?
Only if the seller agrees.
No, that's not true. They can go get a loan, but it's not a contingency. If they don't, they can go get a loan as long as it doesn't affect the seller's outcome. It doesn't extend the escrow. It doesn't cost the seller any money. And it's not a contingency. If they don't get the loan they want, they can't cancel, but they can redo the loan amount, or let's just pull up the RPA real quick. Back here. So let's say under loan amounts here. First of all, we're talking about a cash sale. So if they made cash offer, where does it say cash offer?
I think it's at the top now by purchase price.
Okay, thank you. Purchase price.
It's 3A.
Oh, there it is, there. Yeah, 3A, thanks, Chris, you would know. So if it's all cash and they've done all the steps in all cash, they can still go get a loan as long as it doesn't impact the seller. And it's not a contingency. Now, the question that came up this week was actually, they had a loan amount here of $500,000. And they wanted to change it to $450,000. Does that kind of create a something that needs an addendum in the contract? No, they can change this loan amount, again, as long as it doesn't affect the seller. And we don't need an amendment to the contract or anything like that if they change this loan amount. So that was something that came up recently. Well, as long as we're in the RPA, let's cover a couple other things. Assignment came up this week, which is 3K. So this is under 3K in our grid. We call this the grid now. Assignment request. So that within 17 days, that's the default. The buyer has the right to ask for, do an assignment. So let's look at paragraph 23 and what it says about assignment. Whoops. Too far. Okay. Buyers shall have the right to assign all of buyer's interest in the agreement to buyer's own trust or to any wholly owned entity of the buyer that is in existence at the time of such assignment. Otherwise, buyer shall not assign all or any part of the buyer's interest in the agreement without first having obtained the separate written consent of the seller as specified. Such consent shall not be unreasonably withheld, blah, 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 blah. Blah, and you use form AOAA to complete this assignment. So often a buyer will make the offer in their own name, but then they want to put it into a trust during the course of the escrow, and they work it out with Fidelity National Title, their escrow company, to put it in the trust name, and the title company gets, the escrow officer gets copies of the trust, and they run it through the title and blah, blah, blah. So yeah, they can put it in their trust, they can put it in their LLC, whatever they want to do without needing the seller's consent. But if they want to assign it to someone else altogether, or add a purchase, another co-signer on another party to the contract, then you're going to have to use that AOAA form to do that. And while we're talking of trusts and LLCs and other entities, purchasers, remember we used to have to do that form, which we call the RCDS, the Representative Capacity Disclosure form, or the Representative Capacity Signature Disclosure. And now it's built into the RPA under paragraph 32 and 33. So if an entity is the purchaser, you would check 32B here, and it says if this paragraph is completed, a RCSD is not required for the authorized signers. So this takes the place of needing the separate RCSD that we used to have to get. And in this form, you're going to put in the name of the legally authorized signer, is the one who's signing up there, is going to be signing on the bottom and is named up at the top. And the party that's the entity is named down here, my LLC. So that takes care of that whole form we used to need to get for the buyer. Same thing with the seller. If the seller is an entity, under 33B, you check 33B and you put in the same thing, the signers, the authorized parties, and the name of the entity, and that's all taken care of. So that's convenient. It's new, and that helps us with that. Any questions on any of this? Okay, just the SFA form came up. Let's look at that real quick. Oh, okay, the seller financing. So once in a while, we get seller financing. And a seller, when there's seller financing, by statutes, California Civil Code here in so-and-so requires this financing addendum and disclosure. This is one of the more complicated forms that we deal with as real estate agents. So I always like to review these. I like our managers, your managing broker, to review these. Because they're complicated. There's a lot of things we don't deal with every day. We got to check all these boxes. You know, the RPA, they've made it pretty clear that there's a default for everything if you don't check the box. Here you got to check the box for tax service. You know, do you know what a tax service is? Who's going to pay for the tax service? You know, the buyer, the seller. we want title insurance. The seller who's carrying financing wants title insurance, hazard insurance, all these things need to be checked. So we don't do this form. We do it very rarely. And this always becomes a confusing part here. Senior loans and encumbrances. What do you put in here? Well, typically when we have seller financing, the seller's financing is the first deed of trust. We're doing one now where it's a land sale and the seller's carrying a first deed of trust for 5 years. There's nothing here. You don't have, this is senior loans and encumbrances. There's no senior loan. Now, rarely would we have a seller carry a second mortgage that's subject to a first mortgage. Then this would get filled out. So that's one common area. So the agents would fill this out with the details about the current loan, but it's the first loan, so that doesn't count. Now the party, there's stuff about the creditworthiness and so forth and so on. The party creating this form, the responsible for creating this form is the buyer's agent. You would put your name in there, actually. So it's Chris Brown is the arranger of credit, and would put down and it says print firm name, so you put buyer's agent, you would put actually BHG, WCG or MG would be the arranger of the credit if they're representing the buyer. So if you are the listing agent, it's still incumbent that we get this form by the statute, but it is the buyer agent's responsibility to do it. So if you're doing a seller financing, please review that with your broker manager because it comes up periodically. Last thing I want to cover is the FHA VA addendum. When you have an FHA or VA loan, this form is required. A mandatory clause. Make sure you read it and you understand what it says. And you need to put in here the purchase price of the property, $600,000 or whatever it is. Because if the property doesn't appraise for that, the buyer has an immediate get out of jail free card and they can cancel the contract with no liability. So make sure that's filled in if you're using this form. And with that, unless there's any other questions about other transaction stuff, we can go on to our presentation by Fidelity National Title.
Thank you.
Hey.
Good morning, everybody. Thank you for having us. I'm Laura Fitchie. I am the sales executive for the Petaluma and Sonoma area. And I've got Roberto Soto, my sales partner here. And Roberto covers, oh boy, Cloverdale, Healdsburg, Santa Rosa, and Runner Park. So we're thrilled to be here today. Gary, I don't know if you guys know, but we're gonna be going over our buyers and sellers net sheet app. It's a must for every single real estate agent, and it's called Fidelity Agent One. So if you haven't heard about it, please reach out to us so that we can get you set up with it. It's free, and it's gonna make you guys look like rock stars to your buyers and sellers. So with that being said, I think Gary, if you can, if Roberto can hop on and.
Yeah, let me make him a co-host here.
Thank you.
Okay. All right, Roberto, you should be ready to go.
Thank you, sir. Let me just share my screen here.
And we have two ways that you can access Fidelity Agent One. One, which is my favorite, is actually downloading the app from the App Store and putting it on your phone. And it's just Fidelity Agent One in the App Store. The other way you can do it is on your desktop, and it would just be go to fidelityagent1.com. But it just looks it works a lot easier on your phone. So with that being said, the screen right now, what we're showing, you'll see at the bottom, you've got buyer, seller, calculations, and premium. So right now, we're just going to walk you through a quick little buyer's estimate. So from here, what I recommend is if you can go ahead and hit add address. And I think, Roberto, you can just put in my property address, 3867 Lanewood Way, Santa Rosa. And what this does is it does have the option to, it's going to pull in my property taxes for me. So that populated. So all we need to do right now is put in a home price. Let's do 800,000. We don't need to worry. Well, yeah, we do. So if there's going to be a loan, you can click on the loan type, Roberto, if you can actually click down so you guys can see the options here. For this, because we're giving you guys a quick little demo, I'm going to use all cash for now. So I'll have Roberto just check that box right there. The hazard insurance is what we use in escrow. The taxes it pulled in. The transfer tax we don't need to worry about because that's a seller pay. And then the closing date, I recommend that we move it out a month. And then we hit calculate, compute. And look how fast this is. So when you look at this, what I recommend is you click on the, in the blue is the hyperlink, detailed closing costs. And it gives a nice little breakdown, because I think the main thing that your clients are going to want to know when they're buying a home, how much is the title? How much is the escrow? If there's a termite inspection, you have that in there. You have the option to take that out as well. Then you've got the prorated tax and the recording fee. You can edit it by just clicking on the little edit button. If you wanted to add maybe a home warranty, any other buyer costs that you want to add on, but just knowing that that title and escrow is 100% accurate and it's set. So you can't, play around with it. The other nice thing about this app is you can change the county. So you can get the correct title and escrow fees for any county and even outside of California. So a lot of times you guys are working maybe Napa and Marin, so you'd want to go in and change the county so that you have the accurate fees. From here, you can just go ahead and hit on the top right, you'll see the little box that you can upload it. Click send full report. And then Roberto's going to show you a couple different templates that we have available that you can change. It's taking a little minute here.
Yeah, so it's all loaded there. If you go to the bottom left, different templates you can use just depending on, what your style is, the way you brand yourself, but it's actually going to allow you to choose different templates here so you can export the one you want that looks best for you. And you can email this, put this on straight to Facebook, Instagram, text it to your clients. You can even print it out. So
you can also customize it on the bottom. A lot of times I do these, just so you guys know, Fidelity, we do your net sheets for you. So what this app is for is, after hours, evenings, weekends, maybe you're not in, don't have an open escrow and you just need some estimates. This is a perfect tool for that reason. A lot of my clients will text me on the weekend because they need a buyer and seller net sheet, and that's great. And I'm happy to do it. And I go to my app and do it for you guys. So just keep that in mind. The other nice thing about it is it's going to be, once you download it, it's going to be branded to you. And so you can actually choose, the Better Homes and Gardens colors and stuff like that as well. But from here, let's go out and do a seller's, unless anybody has any questions on that. So I really like this app for a seller's net sheet because a seller typically only pays commission, transfer tax, and a notary. So it's really easy to be able to prepare that. So again, with the seller's estimate, we're going to put in the property address. We're going to put in a sales price. Let's do 800 again. The only other thing you're going to want to check will be the broker fee. And you can click on the wheel and that will let you change that if you need to, if you want to change it to 2.5% broker, 3% listing, or we can just leave it at 6%. If there's any repairs, you can put that in there. The other thing I use a lot is the miscellaneous. With the miscellaneous, it'll let you add maybe a home warranty. Again, it'll let you add maybe a pest inspection, or it lets you subtract from the closing costs. We don't need to add anything there. If you have the loan balance, you can add that. Otherwise, the city transfer tax. There's only 2 cities in Sonoma County that charge a transfer tax, and that's Santa Rosa and Petaluma, and it's $2 per thousand. So you would just check the little box and then the closing date again, and then hit compute. And then if you want to click on the detailed again, and it shows you the little breakdown. And that's typically what a seller will pay for. If the 593 form is the state of California form that they charge, and so we pass that charge on to the seller. And that's it.
You can also export that the same way as the buyer. So send full report, choose your template, you can export that the same way. So take it to your listing appointments, things like that.
Very good. Very good. Thank you.
Yeah, so mostly what you'd use this for is for the buyers and the sellers. There's a couple other features in there, but we'd love to have a one-on-one and be able to get you set up on your phone and walk you through it. And I think you guys will really like it.
Great. Give us that app name again.
Fidelity Agent 1.
Fidelity Agent 1. That's Fidelity Agent 1.
I'll put it in the chat here.
Just feel free to reach out if you need any help setting it up. Let us know. We're more than happy to walk you through it.
And that's Agent 1, what, O-N-E? Okay.
Yeah.
Okay, great, thanks. And we got a comment that it's a nice app. Thank you for sharing.
Yeah, it really is. I'm just putting our contact information in the chat with our emails.
All right, and there's a couple comments in the chat. The seller net sheet was super useful when my client, the wife, needed to convince her husband to sell. Very good.
Great.
Marmita and Greg says, I just downloaded it. It's very easy to use. Set up.
Oh my God, you guys are awesome.
These are fast.
All right. Any questions for Roberto or Laura at Fidelity National Title?
Thank you so much, everybody.
Okay,
A
and
pleasure.
if any other questions on any other matters we can cover? Otherwise, we'll catch you next week. I think we have some other MoxieWorks. I think we have the MoxieWorks in-person trainings next week in some of our offices. So I'm sure Heather will send out a reminder. And if it's not in an office near you, you might want to travel because that's going to be a hands-on MoxieWorks training with your computers and, setting yourselves up on the different MoxieWorks platforms that we're using now. So keep an eye out for an update from Heather. And I think that's what we got for today. So everybody have a great weekend. Go sell some houses. We'll see you all later. Thanks, Laura, Roberta.
Thanks for having us.
Yep, thank you. Bye-bye, everybody.